Welcome to the Ask Junior Daily Judgment Podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's important judgment. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now let's get started with today's case. Today's case, Krishna Devi Sabitri Devi, Rani versus Union of India and Ors, revolves around the crucial question of when the clock starts ticking for filing objections to an arbitration award. This is a complex issue with far-reaching implications for the arbitration process, so let's break it down.
Absolutely. This case is really about the balance between formal legal procedures and practical realities in arbitration. We're going to examine whether formal notice is absolutely essential for triggering the limitation period for filing objections, or whether actual knowledge of the award is enough.
Let's first look at the key facts. In 1987, the appellant's husband, as the sole proprietor of MS/SR Engineering Construction, secured a contract from the Union of India to build a permanent armament section at Tezpur. The contract included an arbitration clause, which came into play when the appellant's husband's firm completed the work but wasn't paid by the respondents.
The legal battle went on for years, with multiple proceedings in different courts. The appellant first tried to initiate arbitration, but the respondents declined. Then, the appellant attempted to initiate arbitration proceedings in different courts, but those were dismissed due to jurisdictional issues. Finally, in 2019, a district judge in Sonitpur allowed the appellant's application and appointed an arbitrator.
Unfortunately, the appellant's husband passed away during the arbitration process, but she continued the proceedings as his legal heir. The arbitrator finally issued the award in May 2022, ordering the respondents to pay a significant sum with interest.
However, the story doesn't end there. The respondents hadn't cleared their portion of the arbitrator's fees, so the publication of the award was delayed. To address this, the appellant filed an application under Section 38 of the Arbitration Act, 1940, seeking an order for the respondents to pay their fees. The court ordered them to do so in September 2022.
The appellant received a copy of the award on September 22, 2022, while the respondents received it on November 18, 2022, after clearing their fees. The appellant filed an application under Section 17 of the Arbitration Act on November 10, 2022, seeking judgment according to the award. But both the trial court and the High Court dismissed the application as premature, considering that the formal notice had not yet been served on the respondents.
This brings us to the key legal questions raised in this case. Firstly, does the limitation period for filing a Section 17 application under the Arbitration Act begin from the formal notice or from actual knowledge of the award? Second, can informal communication or knowledge about the existence of the award satisfy the notice requirement under Section 4.2 of the Arbitration Act? And third, was the application filed on November 10, 2022 premature, considering that formal notice was only received by the respondents on November 18, 2022?
These are crucial questions that impact the entire arbitration process. We need to determine how procedural requirements are balanced with the need for efficiency and fairness in resolving disputes.
Let's delve into the Supreme Court's reasoning. On the issue of when the limitation period starts, the court examined both Section 14.2 of the 1940 Act and Article 119B of the Limitation Act. While Article 119B requires service of notice, Section 14.2 only states that the court should give notice.
This subtle difference is key. The court argued that the intent of Section 14.2 is to ensure that parties are aware of the award's existence to file objections, not to impose additional procedural requirements. The court also emphasized that interpreting it as requiring formal notice could lead to delays by parties who are already aware of the award.
The court also delved into the sufficiency of informal notice. They analyzed precedents to determine what constitutes valid notice under Section 14.2. Citing previous rulings, the court stated that the term notice doesn't exclude informal expressions.
Imagine a scenario where you're invited to a friend's birthday party. You might not get a formal invitation with all the details, but hearing about the party from a mutual friend is enough for you to know it's happening and make plans to attend. Similarly, the court reasoned that Section 14.2 doesn't require a formal, written notice.
The court emphasized that the objective of Section 14.2 is simply to inform parties about the award's existence, without specifying any particular form of communication. Insisting on rigid procedural formalities would hinder the speed and efficiency of the arbitration process.
Now, regarding the validity of the Section 17 application, the court found that the district court's order of September 21, 2022, directing the respondents to clear the arbitrator's fees served as sufficient notice of the award's filing.
This is key. The court reasoned that this order clearly indicated the award's existence and accessibility, making the respondents aware that it had been filed.
Think of it like a public announcement. The court's order was like a loudspeaker announcement at a public gathering, letting everyone know about the event. In this case, the order served as a public declaration that the award had been filed.
Drawing from previous cases, the court held that mere awareness of the award's accessibility triggers the limitation period, not the receipt of formal notice or a copy.
This is a crucial takeaway. The court underscored that allowing respondents to rely on later formal notice, despite earlier knowledge, would reward their inaction and delay the arbitration process.
Ultimately, the court provided a substantive interpretation of Section 14.2, emphasizing its functional rather than formal nature. They reasoned that treating the notice requirement as merely procedural could lead to parties exploiting technicalities for delay.
The court's decision highlights the importance of balancing procedural fairness with practical considerations. By recognizing the sufficiency of informal notice and the significance of actual knowledge, the court encourages the swift and efficient resolution of disputes through arbitration.
This judgment has several significant implications. It emphasizes the importance of actual knowledge over formal notice, ensuring a more efficient and practical approach to arbitration. It also discourages parties from delaying proceedings by relying on technicalities.
The court's decision reinforces the principle that the arbitration process should be focused on resolving disputes rather than bogged down in unnecessary procedural hurdles. It is a significant development in arbitration law, setting a precedent for future cases.
And that wraps up our analysis of today's judgment. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Sharma.
And Arjun Gupta, signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.